Yeah, that was the state's case, basically all laid out there. Carly Dufeld, prosecutor, who was basically, I'd say, the lead, right, in this. She did a lot of the questioning. It was kind of a co-prosecution scenario. Laying it out for the jury, that was bits of the open and the close all mashed together. Let's bring in our guest this morning, trial attorney, former president of the National Bar Association, C.K. Hoffler, still with us from Georgia, and in Denver, Colorado, criminal defense attorney Jeffrey Wolf joins us. All right, Jeffrey, to you first, since you're the newcomer. This jury's been out 3 hours, 45 minutes now on our clock that is ticking away. You read anything into that? Is it getting to the point where you'd think they'd come back with a verdict by now, or we're still early on in the process? After all, this is serious business, and there are 7 charges.
Right. It's very hard to know what goes on in the jury room. Unfortunately, us lawyers very often do not get picked for jury selection, so we don't get much experience back in that room. But what I always try to tell my clients is that I have seen fast guilties, fast not guilties, slow guilties, slow not guilties. You can't read anything into the timing of it. It is the personalities in that room and what they have decided to do prior to making their decision and making it final. One of the things that I would wager that they're probably struggling with back there is the why. There's been a lot of evidence to tie Isaac's to these murders and to say that he should be convicted of these murders, but nobody has been able to give a why. And I know from talking to jurors after they return verdicts that a lot of times, if there is a delay in a verdict, the why can be something that is nagging at least 2 or 3 of them to say, how can we know that this guy did it when we don't have a reason why he would have done it? And so I think that that is likely something that they're struggling with. But again, the personalities of the jurors in that room can lead to a longer time being taken or a shorter time being taken. What I always try to tell my clients is as you approach a meal, that's when you start thinking about, are they going to return a verdict or not? Are they going to stay for that lunch that the court's going to provide, or do they want to go home and have lunch? And so I think sometime mid-morning, if we don't see a verdict, we could start thinking they're going to stay through lunch.
All right, the old meal theorem. I like that, and it's true. A lot of times the verdicts come in right after the free lunch. CK, you've got a rust stain on the defendant's vehicle that matches the rust stain on the vehicle captured on surveillance video. You have that orange hoodie found in his dryer, a knife with a bent tip found in his dryer, gun parts in his freezer and a soup can. What stands out to you as the most compelling evidence that ties these horrible crimes to the defendant, or is it a combination?
Quite frankly, Ted, it's a combination. In a case like this, where there is the why question, where there is no motive that's articulated, you have to look at all of the evidence, and there's just so much evidence that ties this defendant to the murders. And I think suspicious behavior. This is very awkward. You have an awkward, uneasy feeling when there are, when there are bullets in microwave, when you've got things in a freezer that shouldn't be in a freezer, bleach everywhere. There are probably 10 items that are very damaging. And I think the totality of that is what gives a strong impression of guilt, beyond a reasonable doubt in this case. And then you have the defendant himself. He looks very odd, and he looks like he could do these odd things. And so I think that all of the above is probably, all of those things are what the jurors are looking at. And I think those things together are going to sway the jurors one way or the other. It's really an all or nothing case where either they're going to be totally persuaded, put aside any possible question of why or motive, or they're just not going to be persuaded at all. I really don't think there's going to be a middle ground in this case.
Jeffrey, that oddball factor, and being an oddball doesn't mean you're a quadruple murderer, but it does not help. And he didn't take the stand. There's no background. And, he had 16 pairs of the same exact shoe all stacked in the corner of his office. That's odd. And if you're a juror and you've been presented by the state of North Dakota that got up there with their lead investigator, or one of their lead investigators, and said, hey, we don't have a motive. Why don't we have a motive? Well, we think in this case, this guy might have just been doing it for fun. If you're a juror and you've got an oddball, the state claims is just killing people for fun, that in itself would, I would think, be a huge advantage for the prosecution, only because as a jury, you're thinking, well, gee, we can't afford to let that guy out just in case he did do it.
Well, and that's exactly what you hate to hear as a defense attorney, is that people think of somebody like that. Number one, the oddball part of it, and number two, just in case we should convict him. It's proof beyond a reasonable doubt. It's not proof beyond I hope this guy isn't sitting next to me at McDonald's the next time I go there because he's odd, because he has the same kinds of shoes. I hate to hear, and it is common, you're not the only person saying this, it is very common, what we hear is that the way somebody looks, the way they present, who they are as a person that has nothing to do with the crime is a reason to potentially convict somebody. How they sit at the defense table, what their facial expressions are when people say things. All of those things matter, and it's really, really troubling, and it's one of the things that I wish our justice system could get past. It might get rid of some of the racial disparities in our justice system if we stopped caring what people look like as they sit in the defense chair. It is a problem that somebody can't have idiosyncrasies in their life and can't have odd things that they do and not be worried about as being a murderer who's doing it for fun. There should be evidence of that. There should be something that the prosecution can present that is actual evidence of malice, that somebody would go out and kill for fun. That is calling him a psychopath. That is calling him a sociopath. So where is the evidence to back that up? Where is some psychological evidence that this is who this person is, outside of the fact that he likes to wear the same type of shoe? What I have actually heard on the flip side of that coin is that people who wear the same thing every day are very successful because they've taken that decision out of their life and they can move forward to their day, like Steve Jobs with his mock turtleneck. Was he odd? Was he somebody who could kill for fun? That is a very, very troubling road to go down for a criminal defendant in the United States justice system, because many people, when that kind of a lens is put on them, the reason that they're going to jail is because they're black or because they're Hispanic or because they don't speak English. That is a troubling, troubling trend. I hate to hear it.
Yeah, and to be clear, I was laying it out as a reality in our system. It is absolutely a reality. CK, to Jeffrey's point, how do you get around that? It's just part of the equation. Bruce Quick did an excellent job in his close of painting the other side of the picture, because on paper, this defendant doesn't have any reason to do this and has zero criminal history, no disciplinary issues when he served honorably in the Navy, honorable discharge, has a job, he's a professional in the community. So was it wrong for the prosecution, and they did it through a very seasoned detective, get out this theory of, ooh, he's the scariest guy on earth, he just kills for fun? Was that irresponsible?
I don't think it was irresponsible if they believed that to be the case and if there was evidence of that. And I want to go really to Jeff's point. It's not, in this case, it's not just that he looks odd in the courtroom. It's not just that he seems a little odd or has 16 pairs of shoes. There's very, very incriminating evidence that links him to the murders. I think that it's the oddity just makes it worse. But the oddity alone would not be enough, should not be enough. Racial profiling is something I'm completely against, whether it's in the courtroom or anywhere else. That's not what this is. There's other evidence that ties him. So when we look at gun casings in a sock, when we look at all the other things, the evidence that they found in his home that can be linked to these murders, that's the evidence that I think that the prosecution is focused on. The other stuff is window dressing. It's sort of putting icing on the cake that he looks kind of odd, that he has the 16 pairs of shoes, that just goes towards oddity. I wouldn't be concerned about that. But that other stuff, those other 10 items, I'd be very concerned about that if I were the defense. And the defense is trying to tell a story of someone who has no reason to, who served this country honorably and all that. That's great. Storytelling is great. But I think there's a mountain of evidence that speaks to something different. And I think it's going to be a tough call, but I do think the jury will be swayed more by that other evidence that has built up against him and tying him to those murders.
All right, we're going to step aside to talk about the defense. We're going to look at the defense case when we come back. The jury has been deliberating now for about 4 hours. What did the defense bring to the table here? Well, they put on a case. It wasn't long, but they did put on a case. We'll talk about that when we return. Stay with us. Oh, Mitch Kessel, he is the boogeyman. He's the other one that the person that the defense was able to use as the alternate suspect. He was an individual that worked at RJR at one time, was apparently back and forth working there and had some allegations of inappropriate behavior there. Whether it was true or not, we really didn't know because we never saw the guy. But the defense used him as that other alternative for jurors to possibly latch on to. Let's bring back in our guest this morning, trial attorney, former president of the National Bar Association, C.K. Hoffler, is with us from Atlanta, Georgia, and in Denver, Colorado, criminal defense attorney Jeffrey Wolf. C.K., this is very common where, the defense has to sort of give jurors something to latch on to, right? Who else could have done this scenario? And in this case, it's unique because the defendant doesn't have not just a clear motive. It doesn't seem like there's any real motive at all, except he has an association with RJR. They are the property management of his community where he lives. But the other person that they laid out there to the jury is a little bit more intimate. He worked there, he was fired, he was back and forth, maybe that guy. What's your take of that strategy in general, and in this case, do you think it could have stuck?
I think it's a decent strategy in general because you want the jury to look there. They have to create reasonable doubt on some level. But they got to be careful because they're also saying, on the one hand, one person could not have done this because it just would take more than one person. So now they're identifying one person who they're saying could have done it. So they're kind of speaking out of both sides of their mouth. But I think that it is a good strategy generally to have someone who they are identifying could have done it. But, if you're not seeing that person, hearing from that person, and don't have amount of evidence against that person, sometimes it can leave more questions in the jury's mind and can direct them back to the person who's being prosecuted.
And Jeffrey, to be fair to the defense, they also threw out the other possibilities. That this is inherently a difficult business. If you're a property management company, you have owners of that property that you have to deal with, and then you have the tenants that you have to deal with, that you are collecting rent from. There's always issues within just inherently in this type of business, and they threw that out there as well. Your thoughts?
Well, I think the big issue is you have to pick a horse and you have to ride that horse. And I agree that they are kind of speaking out of both sides of their mouth, right? Because they have multiple theories of how this could have happened. The wife could have been out for revenge and hired somebody. This former employee could be the issue, and he could have come back with an axe to grind. Takes multiple people to do it. He has no motive. You have to pick a horse. You have to ride it. And so,
but Jeffrey, if you pick a horse, then you do box yourself in on some level, don't you? If you don't have the goods, a juror is going to turn on you, and the state can turn on you quickly and say, here's why your horse is of a different color. It doesn't work. And they'll bring in evidence and kill your case.
Yeah, but if you're a good attorney, you're not picking the horse that has the ability for the prosecution to do that to you. What you're doing is you're examining the different theories of the case, picking the strongest one to go with, and going with it. Because a jury doesn't want to see you throw as many things up in the air and see which one flies. They want you to pick something, and they want you to go with that and actually believe in it. Because if you don't believe in your own theories, why should anyone else? It is a cardinal rule of criminal defense that you do not give multiple explanations for something. You pick a horse and you ride it. That is the strongest defense imaginable. Now, this case might be just so unbelievably hard to defend that they have no choice but to come in and offer a bunch of different theories or to switch horses midstream. But it's not the most effective way to lawyer. It just isn't.
One of the other defense theories or arguments, if you will, that they brought up to this jury in their close was the fact that this individual just isn't who you think he is. If you look at his record, take a listen, they say he's not a serial killer.
This is a tough business. Difficult owners and probably more difficult tenants. They're often forced to evict people. They're often forced to bring lawsuits suing people. It's hard to keep employees in this environment sometimes as well. There's several examples of tenants threatening RJR employees with threats, verbal, and even with guns. They estimated they do 5 to 6 evictions per month. I think Jackie Faulkner actually said it seems like it's one a day sometimes. Several lawsuits pending at any given time. Justin Bachheim said that Robert Faulkner and William Cobb would often go together, depending upon the severity of the case. Jackie Faulkner testified that at least 5 employees carried guns. Both Cobbs, she and Robert, an employee she only identified by the name of Chris. Dr. Isaak, small-town chiropractor at the time of the crime in his mid-40s, born, raised, educated in North Dakota. Served in the military, honorably discharged, Good Conduct Medal, National Defense Service Medal. Lived in Hawaii, Iowa, where he received his chiropractic degree, North Dakota. Divorced, 1 daughter. No criminal or disciplinary history of any kind in military or civilian life. Chiropractor from some 14 years or so. Nothing to suggest in this trial that Dr. Chad Isaak in midlife would turn into a serial killer.
Coming up, day 3 of the R. Kelly trial. We're going to take a look at what is happening in New York. That's next here on CourtTV. Stay with us. All right, we need to switch gears because there is a verdict in North Dakota. Just been informed by our team there in Mandan, North Dakota, that a jury has come to a verdict. You see the clock in the corner of your screen has stopped. 4 hours and 30 minutes. It has taken this jury of 6 men and 6 women to come to a verdict. It will be read in the next 30 minutes or so. The judge is giving all the parties an opportunity to make their way to the courthouse. C.K. Hoffler and Jeffrey Wolf still with us. CK, I know what you think. I think everybody thinks, but you never know, right? Your thoughts, though, hearing that there's a verdict 4 hours and 30 minutes in after deliberations.
I really believe he's going to be found guilty, or best case scenario, that there might be a hung jury. But I don't think that he will be acquitted. Likely
not a hung jury, Jeffrey, only because we haven't had a note, and typically a jury would, be an Allen charge, et cetera. Could be a split verdict, maybe, but with some of the other charges, there were 7 total. Your thoughts?
Yeah, I think that it's likely to be a conviction. There was really strong evidence in this case. They didn't struggle quite as long as they might have if they were really trying to figure out if they needed a motive or not. So I think coming back at this juncture, I think it does lean that way. I also think DeGuerin and Chesnoff are pretty happy that we're not going to have a nice chuckle over them laying on the floor just then. They got saved by the bell.
Yeah, absolutely. CK, as an attorney, you kind of have a gut feeling of what's going on, but you never know. Do you think these prosecutors are, they want to see it, right? This is a tense time for everybody, obviously for the defendant, but for the attorneys on both sides. They've invested so much of their time and effort, and here we are. What's it like to be in this position?
It's a fate. It's very, very difficult. When you're waiting for that verdict, you literally, your stomach is turning. You're sweating bullets. You can't sleep if you have multiple days like I have of where jurors are deliberating for multiple days. And it's a very, very difficult time. And it continues until you actually hear the verdict. And so it's very difficult because you're second guessing every bit of evidence, every question you ask, every cross-examination, your opening, your closing, voir dire, all of it. And it comes down to that moment. And then you're watching with painstaking detail when the clerk gives the verdict. The jury has a verdict. The clerk gives a verdict form to the judge. The judge looks at it, reads it, makes no expression, then gives it back to the clerk, depending upon which court, and it's read. And all of that is played out in slow motion while you're about almost to throw up. That's just my experience, and I hate to be so graphic, but it's a bad time if you're the lawyer, but that's what we do.
Yeah. All right, we're going to slip in a break here again. A verdict is in. We will have it for you when it is read in about a half hour from now. Stay with us. All right, joining us from Marion County, Iowa, the Marion County Attorney, Mr. Ed Bull, and still with us, criminal defense attorney Jeffrey Wolf. He's in Denver, Colorado. Ed, welcome to you first. Your thoughts on the timing, 4 hours, 30 minutes, seems somewhat appropriate given the complexity of this case. A lot of evidence against this defendant. We don't know what this jury has come up with. Your thoughts?
Good morning, Ken. Thanks for having me. I mean, I think first and foremost, you never want to put a number on a jury, how long it's going to take, but I think every prosecutor and defense attorney does that. They have that little scale in their head as to what they think a jury will do and when. I think it's also important to remember this was split overnight, so juror gets back in the deliberation room. You hope they have taken the judge's comments to heart to not have discussed the case prior to getting back and locked into that room. They're going to pick a four-person, 900 exhibits, 2.5 weeks evidence. You're going to talk through it. And quite honestly, my guess is they voted, they went home, and someone said, you know what, I'd like to sleep on it. They come back. First thing the next morning, my experience in history tells me this is guilty, top charge. Otherwise, it would be a little bit different coming back the next day.
Jeffrey Wolf, your thoughts?
Yeah, I tend to agree with the way the timing broke out and everything else involved here in these deliberations. It does kind of line up that way. And this case was interesting because it completely was absent of motive, but it was just full of evidence. It's a very, very strange situation. One thing that I was telling one of my colleagues about this case when I was discussing it was that they either caught a serial killer potentially early, or God knows what else could have gone on, or they got the wrong guy, and there's just no in between, in my opinion. I don't see any motive to say why he would have done just this one act. And I think that is probably something that the jury had to struggle with, because that is a very large decision to say that with no motive, we believe this guy went out and killed these people. We have no idea why. It's just a random, gruesome, violent, quadruple murder. That's a really hard thing to wrap your head around. And so sleeping on it feels right.
The verdict came in about 10 minutes ago. And the judge has allowed a 30-minute window for all of the parties to gather. You've got the attorneys, you have family members, and members of the community, and members of RJR. They were in the courtroom during the close. Some of them may be making their way to the Mandan courthouse there. Ed Bull, what is this time like? Yes, it does look good for prosecutors, but as an attorney on both sides, what goes through the emotions you're feeling? And obviously for the defendant, it's a tough time, but for everybody, is it not?
It's absolutely awful. It's nauseating to the top degree. It's you're going up the top of a roller coaster and you're at the very peak before it drops. You're second guessing every decision that you've made, but you're also mindful and concerned of, have we notified everyone that we need to? This is where the support staff of a prosecutor's office is so incredibly valuable, to have victim services people, because victims and families and crimes of this nature, we live it, but we go home at the end of the day and we see our families, we do other things. For the victims of this offense, this is all they've thought about for almost 2 years now. And so you want to be absolutely certain that you have prepped them, that you've talked to them, and you've tried to explain to them you've done the best job that you can, but there's no way of knowing what the jury paid attention to or what they found important. And the absence of a motive has got to be just absolutely devastating to this family as well. There's no reason this happened. No one wakes up and wants to be the victim of a crime, and it's even worse when you have no idea why it is that your family, this happened. There's no link. And so it's a terrible moment, and you're just trying to give this family as much comfort as you possibly can, while at the same time explaining to them there's the possibility this trial could go a different direction. So you don't want them to be completely blindsided by whatever this verdict may be. So there's a lot of moving parts behind the scenes, and I know oftentimes viewers are sitting there going, well, why are we waiting 30 minutes? I could tell you, as a prosecutor's office, we need every bit of that time to make sure everyone is where they need to be, so that this can go off with as much compassion as possible for everyone involved.
Jeffrey Wolf, on the other side of the coin, when you have a defendant in a situation like this, this is, he's incarcerated, so they're bringing him up too. Do you make a point of talking to your client before this moment and reminding him, not to react, et cetera, because of potential appeals, and you don't know what's going to happen?
Yeah, absolutely. One of the last conversations I have with my client before the verdict comes in is regardless of the verdict, zero emotion. You don't celebrate a win, you don't mourn a loss. You do not react to it. You do not want to be seen as being disrespectful to a verdict or disrespectful to the courtroom. You just take the verdict and go from there. And, to speak to kind of the other side of that equation, I know what DA's offices are going through in a case like this to get everybody into the courtroom. But I can tell you from the defense side of it, waiting for the DA's office to get their ducks in a row and getting in there is extremely, extremely excruciating for both defense counsel and for the defendant as well. And, obviously there's sensitivity to, there's a family of victims here, regardless of the verdict here. So there's sensitivity to get them in there. But I find often what you see is the DA has gone back to their office, which is often down the street, and the defendant and the defense attorney are sitting there waiting for the verdict because they don't have anywhere to go that would keep them within the arm's length that the court is requiring. And the arm's length is often where's the DA's office. And so there is another side to this, and there are two sides of these cases. And so it is important to realize that Mr. Isaak and his attorneys are now sitting there waiting for the DA's office to be ready, because that is almost always how that goes.
Ed Bull, the prosecution in this case, let's face it, murders don't happen very often in this area of the country. Quadruple murders, unheard of. How have they done wrangling in the complexity of this case when you talk about the video, the 900 plus pieces of evidence, and then their presentation? You do this for a living. Rate their performance.
Well, you train for it. No one wants to have a murder happen in their community, but you have to be prepared to rise to the occasion. You practice and you try the domestic violence cases, the OWIs, the driving while suspended, because you are trying to keep yourself sharp so that when the eyes of the world are upon you, you can rise to the occasion and deliver the performance that you need to. And they did that. You can certainly tell there was not. There can't be an argument of a rush to judgment. There can't be an argument about did they take their time to find the right person, notwithstanding the arguments of defense counsel's closing. There was a tremendous amount of evidence, and they systematically took an approach to this case of not a lot of pomp and circumstance, but rather this is what the evidence revealed, and this is how we went about what we did. And so to that end, I think the key to every prosecutor, and I was a defense attorney for 10 years, is to find your voice in that courtroom and don't be something that you're not. If you're just the facts type person and you're not going to try to come in with flair and story, then be who you are. Be who you are in the OWI trial and be who you are in the murder trial. There's a reason why you've been put in the position that you have been. Your bosses, the public have confidence in you, and every once in a while you get to step up, say, may it please the court, and present the argument that you were meant to give. And that's what this prosecution team did over the last 2.5 weeks.
Jeffrey Wolf, in every case, there are victim family members and other interested parties. In a case like this, you have an entire state that is zeroed in on it. This is something that rocked the state of North Dakota. It was a national story when it first happened. So how does that play in terms of the pressure for everybody involved, from the judge, the prosecution, the defense, and even jurors?
Yeah, and we just had that case in Colorado. We had the red wine case that captivated our state for almost a decade. And so it's an immense amount of pressure. I knew one of the defense attorneys on that red wine case. And so you see the shared experience of someone being thrust into the spotlight and getting this case that not only is the state of North Dakota watching, but as we're sitting here on CourtTV, the entire country is watching. The amount of pressure that puts on any judge, prosecutor, defense attorney, everyone that is normally doing this job and knows what they're doing, or they would not be there, as my co-person here is saying. They wouldn't be there if they didn't know what they're doing. But it's an extra level of pressure, and it's, are my rulings correct if you're the judge? Is my demeanor appropriate if you're everyone? Am I able to get the words out of my mouth and get it to be effective and good communication that I'm not only giving to the jury who I'm looking in the eye, but also to everyone that's watching on the other side of that camera? Anytime you have a case where there's a camera in the courtroom, there are eyes and eyes and eyes multiplying on you. And one of the things that's come out of COVID is maybe we've gotten a little bit more used to that. because if you've done anything during COVID, you've gotten a text message from a friend or a colleague saying, hey, I was watching on WebEx, good job, or, oh, you really flubbed that one. So it's becoming, I think, something that people maybe have been able to get more used to over the course of the last year and a half, but you can't possibly understand the microscope that gets put on these lawyers and on this judge. I mean, look at what Judge Ito had to say about presiding over the OJ trial. It completely changed his entire life and career and mental health. So yeah, it's there.
Yeah, absolutely. We're going to get a break in here. The parties are gathering now in Mandan, North Dakota. The verdict is in 4 hours, 30 minutes. It took this jury of 6 men and 6 women to come to a decision about the fate of the defendant, Chad Isaak. We'll hear that decision when we come back. Stay with us. Forgive me if I cut any of you off. As soon as we get word that the judge is on the bench, we're going to get you into the courtroom. We're expecting the verdict to be read in about 5 minutes or so, per Chanley's reporting. Ed Bull, we've talked about this before. You've been in this position before. The drama, you could feel the tenseness in a courtroom, can you not, in these moments leading up to the verdict?
Without question, the tension is incredible. You can cut it with a knife. And I think, as Jeffrey pointed out earlier in our previous segment, the fact that you have all these eyes on you, and the fact that you know that there's cameras, and the fact that you want to make sure that you look as good as you possibly can, that you're standing in the right spot, that the microphones work, all of those type of things also are playing into the consideration. While at the same time, I know how important it is for the defendant to have a poker face, but as a prosecutor, you have to have a poker face too. You can hope and you can know that you did everything you can, but to bring home justice for this family and these victims, but you never know what this jury's going to do. So it's an incredible moment. You're standing there. All you want to see is the panel walk in. And then you're playing all the games that you've been taught from the very beginning. Are they making eye contact with the defendant? Are they making eye contact with the prosecutor? Does the clerk of court who handles the document, give you any heads up of what the verdict's going to be before it's handed to the judge? All of those things, you're trying to pick up on everything that you possibly can to try to know what that verdict's going to be 1/100th of a second before the judge says form a verdict number 1 or form a verdict number 2, however it's done in that jurisdiction. So it's an incredible moment, and you hope that the jury saw it your way.
And yeah, to the point, Jeffrey, where, when the jury walks in, everybody looks to see if the members of the jury look at the defendant or not, or if they glance over at family members. You could try to read the tea leaves in that instant, as Ed said, before the verdict is read. For jurors as well, Jeffrey, this is emotional, and in some cases, something they carry with them for the rest of their lives.
Yeah, absolutely. Anybody that's talked to a jury after they're done, they take it really seriously. People always talk about wanting to avoid jury duty until they do a jury trial, and then they're hooked, and they can't believe that they ever didn't want to be there and be a part of this system. And I could say that exactly once I had a juror look meaningfully at anyone in the courtroom that it tipped the hand of the verdict, which was to look at my client and give one of these, which felt really nice, but it's very rare. And, I think one of the things that's going to be really interesting is how is the jury going to react to the fact that Chanley was just saying that his defense team is not going to be there. Only one of the lawyers is going to be there. I cannot envision a circumstance where I wouldn't stand and or sit, depending on the jurisdiction, with my client to get this verdict with my client. I cannot imagine what could have possibly taken them away. If it was another case, it should have been continued or covered by somebody else. You always plan for the extra deliberation. You don't plan something right up against another trial. I feel bad for Mr. Isaak regardless of the verdict. His lawyer should be there with him. I think it maybe goes back to some of the conflict they had on who was going to be his lawyer and who was going to try this case and whether he was paying and all that kind of stuff. But I feel for him. His lawyer should be there with him.
Chanley, talk about this jury, 6 men, 6 women. You've watched them work. I know there was one juror that was having issues falling asleep at one point. And overall, describe what you've witnessed from them in terms of attentiveness, et cetera.
Overall, a very attentive jury. They're wearing masks, so it's their expression's a bit inscrutable because you can't see half of their face, right? But the sleepy juror was an alternate juror. Interesting here in this case, while the jury, the 12 were deliberating, he kept those 2 alternates on standby. So they were here the whole time, just in a different room. Even this morning, just in case they were needed to step in and be one of those 12 deliberating. It is a jury, like you said, 6 men, 6 women, all white, ranging 20s all the way to probably 70s in years of age. And I would say mostly the older population. Retirees make up most of the
Chanley,
jury.
got to cut you off. Judges on the bench. And Chanley Painter will be anchoring our coverage starting at the top of the hour. Joining our discussion now, along with Judge Ashley Wilcott, Marion County, Iowa Attorney Ed Bull, and Criminal Defense Attorney Jeffrey Wolf. Ed Bull, obviously, in Marion County, Iowa. Jeffrey in Denver, Colorado. Ed, to you first. Your thoughts on this verdict?
I think as we've been talking all morning, this was expected and was not a surprise in any way based on the length of time and just the absolute tremendous amount of circumstantial evidence that the state had and the way in which they put together this case in a systematic, always marching forward, always in command type way. It's not a surprise in any way that this was guilty as charged.
Jeffrey?
Yeah, I'm not surprised either. I think that this verdict was in line with the amount of time it took them, basically the schedule with which they deliberated, as well as the evidence in the case. One thing that made me smile after this was seeing the lawyers give the professional handshake after the trial. I think that too often prosecutors and my colleagues in the defense bar can't see past themselves to, understand that we are still colleagues working in the same system. We are different sides of the coin, so that was nice to see.
Judge Ashley Wilcott, to that point, it is personal sometimes, is it not? Especially a long trial and a trial under this much scrutiny. It says a lot about the character of everybody. They, like you said, Jeffrey pointed out, shook hands.
And I'm so glad Jeffrey pointed that out because I feel like they've had that type of demeanor this entire trial. Ted, here's the thing. It's highly emotional, and people forget that these attorneys have not slept, have not eaten in order to prepare for this trial, which can cause you to have frayed nerves. So it is a real act to really continue that professionalism all the way till the end.
Ed Bull, any chance this defendant is sentenced to anything but life without?
I would be absolutely shocked. This is quadruple homicide with no motive that can be told. This is not a person I would assume a judge is going to put their name on a sentencing order to give this person the opportunity to ever walk among free people ever again.
Jeffrey, at the sentencing hearing, victim family members an opportunity to speak. How important is that for victims of crimes?
It's incredibly important. It's a moment of closure. It's being able to say, now I get my say, and now I get to look at the person who has been convicted of murdering my loved one and say what I have to say. So it's incredibly important and a completely invaluable part of the process. And it was nice to also hear the judge say that they're going to have a counselor for the jurors, because this is emotional for everyone. And there is a lot going on for everyone involved here. And the sentencing being delayed so that people can collect themselves and be ready for it and handle it professionally and appropriately, I think is a great idea.
Yeah, and again, the sentencing will be at a later date after a pre-sentencing investigation is done on the defendant, and it'll be at that point. We'll see if the defendant has anything to say as well, giving the victim family members any insight into why he committed these horrible, horrible acts. He is now Chad Isaak, chiropractor, now convicted quadruple murderer. It took the jury of 6 men and 6 women 4 hours and 30 minutes to come to a guilty verdict. I want to thank Ed Bull, the Marion County, Iowa attorney, and Jeffrey Wolf, defense attorney in Denver, Colorado, for joining us this morning and helping us through this coverage. Judge Ashley and I will be back after the top of the hour. Chanley Painter will be here to anchor our coverage. Stay with us. You're watching Court TV, your front row seat to justice.